back to the program. I'm looking forward to the discussion up next. Martin George, attorney at law, joins me on the Zoom line as we try to dissect and really get a deeper understanding concerning the developments coming out of the Naipaul Kuhlman case. Now, this came into the public's attention since 2006, and from then to now, it's been a total nightmare for, I would imagine, the Naipaul Kuhlman family. Even the family of those who would have been accused, you know, it's a real back and forth. And we are looking at some of the developments from The Guardian from yesterday to today. And this is, well, a real fiasco. Real fiasco. I mean, I'm not too sure really how to gauge this story. So I'm happy that you're here with us to just give us a deeper understanding. So just take us back. Before we get to this lawsuit scenario and the paying out, just take us back to some of the major developments coming out of this case.
Yeah, hi, good morning, Jason, and good morning, Trinidad and Tobago. Now, remember, this case was so interesting because at one point, if you recall, there was an allegation in relation to the husband of Miss Naipaul Kuhlman and some allegation in terms of him attempting to, interfere with the process as regards the prosecution of this matter. There was a suggestion that maybe he should have been charged or, that kind of thing in terms of what he was supposed to allegedly do. Then also remember, Jason, this was a matter that was eventually prosecuted by 3 eminent senior counsels in Trinidad and Tobago. At the time, it was Dana Sitahal, Gilbert Peterson, Israel Khan. So you had 3 senior counsels who had been retained by the state to prosecute this matter. This is a matter which would have had the blessings of the DPP, So in other words, when the police would have collected their evidence, collected their information, you would have gone to the DPP's office to get advice and guidance. The DPP's office and all their attorneys would have perused the information, the evidence you have, and then they would have taken the decision that, yes, there appears to be sufficient evidence to be able to secure a conviction, because that's the only purpose you embark upon a prosecution, that you feel satisfied ab initio from the start, from the get-go, that you have sufficient evidence to be able to secure a conviction. Otherwise, it appears that you are off on a frolic of your own. So if the DPP would have done so, made the recommendation, allowed the police to initiate these charges against these persons, there must have been some level of conviction at the DPP's office that, look, we do have sufficient evidence. So when the matter was eventually ended before Justice Malcolm Holdip, as he then was, he's of course in Court of Appeal now, but I mean, the point is, when the matter would have ended before Justice Malcolm Holdip, and these men were freed, the question then arises when you file a malicious prosecution suit is whether the state can show a credible defense as to why they embarked upon this prosecution in the first place. And it's important, Jason, for us to go to the definition of malicious prosecution. Malicious prosecution is a tort defined in the Civil Commonwealth Caribbean tort law as the tort of malicious prosecution is committed where the defendant maliciously, so in other words, you're saying the state of Trinidad and Tobago, which would mean the DPP on his advice or guidance, maliciously and without reasonable and probable cause initiates against a claimant a criminal prosecution which terminates in the claimant's favor and which results in damage to the claimant's reputation, person, or property. So when
okay, no, I just
when you have a situation where the state does not enter a defense to such a claim, it is almost as if you are admitting and saying to the court, yes, the state maliciously embarked upon this prosecution.
So the ball was dropped from the onset, because I'm thinking.
This is what I'm saying, and that is what is so egregiously wrong with this entire scenario, because you cannot tell me that the DPP, in his wisdom, with all his attorneys, with all the knowledge, the staff, etc., you cannot tell me that you are conceding from the get-go that your DPP, your entire machinery of the state, maliciously embarked on this prosecution against these 9 men.
Let me ask you the Faris versus Reginald argument, because obviously Faris would have been in the office at the point in time when the initial ball was dropped. Now,
Yes.
of course, Mr. Moore will have to take up the slack. What's your, I guess, from the legal standpoint, what's the approach now from the administration to fix this, if there is a fix at all?
Well, I would imagine that certainly first there must be some explanation and accounting and accountability in terms of what happened. Why did the state not enter a defense? If you follow me, I mean, that is, I mean, appalling when you consider it, that something such as this, a high-profile matter such as this, where think of, I mean, people are looking at the 20 million, but that's not the only money that the state lost in this matter. All the fees which would have been paid to those 3 senior counsels to embark on this prosecution, if you are conceding that the state did so maliciously, then why on earth did you even engage the services of 3 senior counsels, spend maybe millions of dollars of taxpayers' money for them to prosecute a matter which you are conceding at this stage that you embarked upon maliciously and without reasonable and probable cause? Because when you don't enter a defense, that is basically what you are saying, because the claimants are saying to the court, yes, they embarked upon this maliciously and without reasonable and probable cause. When you don't enter a defense, you are basically accepting that and admitting that. So you can't resile from that, you know. There's no coming back for the state. There's no coming back for the AG's office to say, well, you know, we change our mind or we change our position to say, no, we didn't act without malice. No, that is a done deal. Judgment has been entered on the basis that you maliciously and without reasonable and probable cause embarked upon this prosecution against these 9 men.
Let me ask you.
So you're starting from a negative there once you allowed the judgment to be entered and you didn't put in a defense.
When the group filed this lawsuit in late May of 2016, a matter of fact, 2016, this would have been 4 years after their release.
2020.
Right.
They filed.
They filed. So there was, I'm watching here of another particular motion where they were obviously talking about the conditions while they were in prison. Does that play into this particular scenario at all? Because I'm watching here where most of them are calling, and well, they have claimed psychological damage. There is incidents where some were forced to drink juice that was sweetened with salt. They're talking about mental torture. Even one of the inmates, there is an allegation of rape by veteran residents of the prison. Does the conditions they were kept in and the conditions they had to endure also play in to this particular suit? Or is that separate and apart?
If we hearken back to the definition that I just read out, it says, which results in damage to the claimant's reputation, person, or property. So in other words, their position to the court was that, look, as a result of this malicious prosecution, they suffered this damage to their person. In other words, so where those things you just cited, those would be the elements that they have put forth before the court, resulting in damage to their person. So the fact of the matter is that, I mean, given the seriousness of this case, it is really interesting to hear, and I mean, we all wait to hear from former Attorney General Faris Al-Rawi as to why the state did not defend this matter. And, you know, I mean, I don't think the public is going to be satisfied with the usual spin that they try to, you know, put out at times, you know, in terms of scenarios such as this. This is an egregious abomination in the face of the public, and it's something that taxpayers are now being called upon to pay. So we really need to hear the answers. And then, of course, even under the watch of current Attorney General Reginald R. Moore, because I think the assessment of damages aspect would have occurred under his tenure, the questions would need to be asked because it appears from an initial reading of the judgment that there was an initial offer by the state that, look, okay, you are asking for $3.5 million each for each person. We are offering $1.2 million. Where did that authority come from? In other words, it could not be that just the attorney who is appearing for the state in court could, of their own volition, come up with that figure and offer that figure. You would have to get authority from, ultimately, it would be the Attorney General to give consent to say, well, look, yes, offer that figure. So I think we also need to hear from our current Attorney General, Mr. Reginald Armour, as to what happened here. You know, if it is that he did not give the authority for that, then of course, yeah, sure, we'd be happy to hear him say so. But we need to know what happened there, because if you start off with that position, it means that you are basically telling the court, listen, whatever order you make, you don't need to go below 1.2 million because we are conceding 1.2 million. So in other words, the state is giving a concession.
Let me ask you.
Not only did you not defend it, but you are saying, look, you think they are entitled at least to 1.2 million each. That needs to be explained.
Let me ask you, before we wrap things up, what picture does this paint on the public canvas, the canvas of the mind of the general populace, regarding, one, the legal system, and more so those higher-ups, those who sit in the office of Attorney General and all those legal luminaries who are really charged with the responsibility to protect our Constitution and to protect us via the laws?
Well, you see, it harkens back to the Piarco Airport matter. It harkens back to the Vincent Nelson matter. It harkens back to so many other scenarios where we have seen state officials apparently bungle and fumble and make missteps and mishaps. And unfortunately, Jason, in this country, nobody really takes responsibility and nobody is really held to account. Look at what happened in the UK recently, where the chairman of the Conservative Party was called upon by the Prime Minister, Mr. Sunak, to resign because of circumstances where it appeared that the chairman used his position to facilitate benefits to himself in terms of some debts that he had outstanding, you know, and some claims that he had with the tax authorities in the UK, right? And he had to resign. So in other words, they have a system where at least there is some level of public accountability. Look at how Boris Johnson lost the prime ministership in the UK. If you understand me, it was over allegations of, you know, lack of accountability and lack of proper due diligence on his part. So therefore, he was forced to resign. In Trinidad and Tobago, unfortunately, we not only do we not make people resign, we promote them and we pat them on the back and we give them rewards and higher positions. That has been our history in this country.
And you know what, Martin?
And we need to draw a line in the sand at some point.
Well, Martin, I want to thank you for coming in this morning, giving us the time to really break it down and leaving us with that trail of thought, because, yes, that reality must change if we have to
if we have to make any progress, because I think in any civilized country in the world, people would be fired over this.
Yeah. Martin, I want to thank you for the time. We will touch base soon. Let's monitor this story and see how things pan out.
Thank you.
All the best. Martin George giving us some legal counsel, taking us back and showing us the step-by-step breakdown of this, well, this most, well, I would say it's interesting of a story. It's it says a fiasco, and it is. It is truly a fiasco. We get ourselves ready to head to Tobago. We have a phone interview with Carol Ann Bridgewood James, the Vice President of the THTA, to give us some details about Carnival in Tobago and hotel accommodations. We head across to the Sister Isle up next. See you soon.